Somebody you know is about to make a 5-figure mistake, maybe a 6-figure one, and they don't even know it yet. They're going to walk into a divorce believing something that simply isn't true. A fact they heard from a coworker or saw in a movie, or read in some comment section at 2 in the morning during the worst week of their life. And that one wrong belief is going to cost them money, time, and leverage they can never get back. Divorce is already one of the most painful experiences a person can go through. But what makes it so much worse is that almost everyone walks into it, carrying myths they think are facts. Confident, certain, completely wrong. And by the time they find out the truth, the damage is already done. So today we're taking apart the 3 biggest divorce myths that I see destroy people's outcomes over and over again. Not abstract legal trivia, the actual beliefs that cause people to make terrible decisions at the worst possible time. Quick note before we start. I'm not a lawyer, and this isn't legal advice. Divorce law is different in every state, sometimes wildly different. So anything you hear today should be confirmed with a real attorney who knows your situation. What I want to give you today is something almost nobody gives you in the middle of a divorce, the truth, stripped of assumption, so you can walk in with your eyes open instead of your guard down. Let's start with the myth that wrecks more people financially than almost anything else. Myth number 1, whoever cheated automatically loses everything. I cannot tell you how many people walk into a divorce believing this with absolute certainty. Their spouse had an affair or lied or did something morally devastating, and they assume the courts are going to punish that betrayal by handing them the house, the savings, the car, maybe even extra custody time, simply as a form of justice. Here's the uncomfortable truth most people don't want to hear in that moment. In the majority of U.S. states, marital misconduct, meaning cheating, emotional betrayal, even cruelty in many cases, has little to no impact on how property gets divided. Most states operate under what's called no-fault divorce, which means the legal system isn't interested in assigning blame. It's interested in dividing assets fairly, based on financial contributions, length of marriage, and other practical factors, not moral ones. Think about what that actually means for a second. The person who did something devastating, something that shattered trust and broke a family apart, in most courtrooms, that betrayal is functionally invisible. It doesn't show up on the financial spreadsheet the judge is looking at. Now, there are exceptions, and they matter. If marital funds were spent on the affair, vacations, gifts, hotel rooms, an apartment for the other person, that spending can sometimes be clawed back into the asset division as dissipation of marital assets. In a small number of states that still recognize fault-based divorce, infidelity can occasionally influence alimony or, more rarely, the division of property. And in any state, if the affair created a situation that genuinely harmed the children's well-being, that can become relevant to custody conversations, though even there, the connection has to be direct, not just emotional. But here's the trap. People walk into mediation or a courtroom expecting the system to deliver moral justice. And when it doesn't, they're blindsided. They've spent months, sometimes their entire legal budget, building a case around the affair, instead of building a case around the actual financial and legal factors that determine the outcome. They lose focus on what matters because they're chasing a verdict the system was never designed to give them. And that brings us to a question that connects directly to the next myth. Because if heartbreak doesn't decide who gets what does? Myth number 2. Whatever is in my name is mine. Whatever is in their name is theirs. This one feels like common sense. It feels obvious. If your name is on the bank account, that account is yours. If the car title has your spouse's name on it, that car belongs to them. Simple, right? Except that's not remotely how most states actually treat property in a divorce. And this myth has cost people enormous amounts of money because they assumed they were protected when they weren't, or assumed something was theirs to keep when it legally wasn't. Here's what's actually happening behind the scenes. The majority of U.S. states use a legal framework called equitable distribution. Under equitable distribution, what matters generally isn't whose name is on an asset. What matters is whether that asset is classified as marital property or separate property. Marital property, broadly speaking, is anything acquired during the marriage, regardless of which name is on the title or account. Your spouse's retirement account that grew during your marriage, even though it's in their name only, The portion that grew during the marriage is very often considered marital property subject to division. The house you bought together but only one of you is listed on the mortgage? Still likely marital property. There's also a smaller group of states, including places like California, Texas, and a handful of others that use what's called community property law. Under community property, with some specific exceptions, almost everything acquired during the marriage is split 50-50, again, regardless of whose name is attached to it. The whole concept of my name, my asset, essentially doesn't exist in those states for property acquired during the marriage. Now here's where it gets genuinely surprising for a lot of people. Separate property does exist. Things you owned before the marriage. Inheritances specifically left to you individually, certain gifts. But here's the trap inside the trap. If separate property gets mixed with marital funds, say, an inheritance gets deposited into a joint account and used for years to pay the mortgage,
let's break down this
it can become what's called commingled. And depending on the state and the specific facts, it can lose its separate status entirely. People who think their inheritance is untouchable because it was always just mine are sometimes shocked to learn that years of commingling turned it into a shared asset. This is exactly why financial documentation matters so intensely in a divorce. Not because anyone is trying to be sneaky, but because the law is looking at the actual financial history, not the name on the paperwork. And people who don't understand this walk into negotiations either overestimating what's protected or just as dangerously, giving up things they didn't actually have to give up because they assumed the name on the account settled the matter. Which leads to the myth that might be the most emotionally devastating of the three, because it touches the part of divorce that has nothing to do with money at all. Myth number 3. Mothers always get custody. This belief is old. It's deeply embedded in our culture. In movies, in casual conversation, in the assumptions an entire generation grew up absorbing, and it is increasingly out of step with how family courts across the country actually operate today. Decades ago, there genuinely was a legal doctrine called the tender years doctrine, which presumed that young children were better off primarily in their mother's care, but that doctrine has been broadly abandoned across the United States. Today, the overwhelming legal standard nationwide is something called the best interests of the child standard, and critically, that standard is gender neutral on its face. Courts are instructed to look at factors like each parent's relationship with the child, each parent's ability to provide stability, each parent's willingness to support the child's relationship with the other parent, work schedules, living situations, and in many cases, the child's own preferences depending on their age. This doesn't mean outcomes are perfectly equal across the board. There are still real conversations happening about whether bias, conscious or unconscious, shows up in custody decisions. That's a genuine and important conversation. But the legal framework itself, the actual written standard that judges are required to apply, does not say default to the mother. It hasn't said that in a very long time. So here's what ties all three of these myths together, and it's worth sitting with for a second. Every single one of them feels true because it matches an emotional logic that makes sense to us as people. Of course, the cheater should lose everything. That feels like justice. Of course, what's in my name is mine. That feels like ownership. Of course, mothers get custody, and that feels like tradition. But courts don't operate on emotional logic.